Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances. Welcome back to Justice Redefined. I'm Sina Shabestary, partner and criminal defense lawyer at Titan Defence LLP.
And my name is Kabir Sharma. I'm also a partner and criminal defense lawyer at Titan LLP, and you're listening to Justice Redefined. This is a podcast where we try to take complex criminal ideas and try to wean them down in a very understandable way for the regular public. And today we're joined by a very special guest. We're very happy to have him here.
Yes, we're joined by Mark Halfyard. We're very stoked for him to be with us today. By way of introduction, Mark's accolades are way too many to name. He is a partner and senior appellate lawyer at Daniel Brown Law. He's worked at all levels of court, including the Supreme Court of Canada. He's certified by the Law Society as a specialist in criminal law. He is a co-author of the Criminal Appeals book, A Practitioner's Handbook, as well as an adjunct professor. Mark, thank you so much for being here.
Thank you guys for having me.
It's a pleasure.
I'm excited.
So Mark, if you can just tell us a little bit about yourself and what your practice predominantly involves.
Yeah, I predominantly practice in appeals and complicated like special motions. Sometimes I get brought in on trials to handle some trial stuff where it's like a legally heavy subject, but most of my work is at the Court of Appeal for Ontario, and I try to get up to the Supreme Court when able, but those cases don't come along every day of the week. So, obviously doing a lot of appellate work potentially gives you a bit more access to that because some of the cases that you argue might eventually end up there. But most of my work is at the Court of Appeal, but I also do a fair number of summary conviction or Superior Court appeals for matters where it may be a less serious trial, but serious to the clients, obviously, but less serious than the stuff that would get up to the Court of Appeal for Ontario.
Fantastic. How many appeals would you say you've done to date?
It's probably closing in on around 400. I've been practicing for almost 20 years, so I do a fair number. I'm fairly busy. I try to do about 20 or 25 a year, depending on how busy it is. Not all at the Court of Appeal, obviously, right. But yeah, across all kind of levels of court. That's probably kind of where I'm sitting right about now.
Okay, could you tell us about maybe a recent interesting appeal that you've done?
Lots of interesting things. We just had some success in a case where a trial judge gave a client the maximum 10-year sentence for a sexual assault as a first offender. It was a really horrific set of facts, but the Court of Appeal found that 10 years for a first offender was demonstrably unfit and lowered it down, not as much as we would have liked, but they lowered it down to 8 years, which is still a very hefty sentence. Right. But that was an interesting case just because you don't often get cases where you can argue a sentence is so demonstrably unfit that the judge was basically too high to warrant it. So that was interesting. Recently had a couple successes on different homicide cases, one last year and one recently at the beginning of this year, which had fairly complicated legal issues. I mean, obviously to me, arguing homicide appeals is probably the most challenging and rewarding part of the job. I just find at all levels of court, they get litigated the strongest by both sides, and people put a lot of work and time into it. So it's nice to see. Obviously, the stakes are extremely high for the client. So it's nice to see those cases get up to the Court of Appeal. And I mean, I don't do enough of them to get up there every year on a homicide. But so those are obviously high stakes and really interesting cases.
Fantastic.
Can I ask you, are you generally restricting your practice to Ontario, or do you ever go out of province?
I was actually just speaking to a lawyer out of province about maybe, getting on one of his cases. I had one case a number of years ago that ultimately the appellant abandoned it that I was going to do in Nova Scotia. And I've done intervention applications because I'm part of the Criminal Lawyers Association's interventions committee. Mm-hmm. I did an intervention request in Alberta on a case. It was actually the the challenge to the sexual offender registry that just recently got struck down.
Yes.
And the Alberta Court of Appeal refused to allow this Criminal Lawyers Association to intervene. We got intervention status at the Supreme Court, and as I represented the CLA at the Supreme Court on that case, and they ultimately struck down the registry. So, so it was nice to see that kind of come through fruition. And a kind of funny story on that. I had there's a case called RL in Ontario, which I was the appellant bringing that case. They set a 5-member, so a larger complement of judges because of the constitutional issues, and it was on the same issue, whether the sexual offender registry was constitutional. We lost at the Court of Appeal. The Supreme Court refused leave. And then 2 years later, Nidlovu, which was the case, like a pretty well-known case at the Supreme Court now, went up to the Supreme Court and they actually accepted the argument. So it was nice for me to at least get a piece of, to be involved in that argument, even as representing an intervener, to make some of the arguments that we were also pushing at the Court of Appeal. And it kind of came full circle. And at least somebody eventually saw the rightness of
that must feel
this argument.
That must feel good.
Oh yeah, 100%. It was very vindicating because particularly and I get that this is a tricky issue. It's like high stakes given the fact, but it was nice. And in that case, what really helped, I think, the case that ultimately was overturned at the Supreme Court is they had a much better evidentiary record coming into it than we had. Like it might have been different. I'm not saying necessarily the Court of Appeal got to the wrong decision because it might have been different if we had a better evidentiary record on our case. So just sometimes it's just happenstance, it's like catching lightning in a bottle. You have to be in the right place at the right time to have the right set of facts before the court for them to intervene, right?
And it's interesting you say that because I thought that the thought that popped into my mind as soon as you said that is that it doesn't seem to be so infrequent for the Supreme Court of Canada to do that, to make a decision with respect to something that goes up or doesn't even grant leave, something to that effect, and then years later on the same issue, same topic, that completely changes or flips. And sometimes even coming out with decisions that are close in time and proximity, but are kind of, they run afoul to the legal principles that they're advancing. So
well, just on that note, they just recently in the condom stealthing cases, I don't know if you guys were following that in Kirkpatrick, a case called Kirkpatrick that went up to the Supreme Court, but they had just decided this issue about 8 years before in a case called Hutchinson, where they said they came to I won't get into the details, but they came to a completely different legal analysis. And a lot of the argument on that appeal was whether or not they were just being asked to revisit a precedent because the composition of the court and the bodies on the Supreme Court had changed. There have been a number of retirements and recent appointments. So, and they came to a different result, largely, what I thought wasn't necessarily on a principled legal basis, but because I think the composition of the court had changed, and they came up to the majority split came down on at a different point, right? So that obviously happens at times.
So I think. I think we can geek out over this stuff all day here, but for the benefit of our listeners, let's go through some very basic stuff. First and foremost, what is an appeal? Yeah,
so an appeal, anytime someone gets convicted of a criminal offense and they feel either the judge got the law wrong or misapprehended the evidence or came to an unreasonable verdict, so came to a verdict that wasn't reasonable based on the evidence that was called, they can seek a review from a higher court. It depends on where the appeal is coming from, necessarily where the appeal gets heard, because different appeals will end up at different levels of court, but it's always a higher level of court than the one that decided the trial matter. And most of my work is at the Court of Appeal, which is for more serious indictable, what we call indictable matters, or serious sexual assaults, murder, kidnappings, robberies, that kind of stuff that would be tried often in front of juries, but not necessarily exclusively. But it's a review of a lower court decision by a higher court to make sure that the lower court applied the law properly, reached a verdict that was fair on the evidence, and or didn't engage in any kind of unfair practices. So there's kind of a catch-all grounds of appeal where perhaps the trial below was unfair for different reasons. And that could be things like, just trying to think of some examples, that could be things like maybe the lawyer didn't do their job properly, the Crown attorney engaged in some type of inappropriate conduct. The judge was biased, although that's rarely an issue that succeeds at the high courts. But there's all these kind of other catch-all kind of general fairness that doesn't really have to do with the evidence or the verdict, but just the process was unfair, right? So you can appeal on that basis as well.
I see.
And can the Crown also appeal if they think that the judge got the decision wrong in their favor?
Yes, they can, but their routes of appeal are slightly more restricted than the defense. The defense has some limited ability to appeal on factual issues, although it's still fairly tightly refined, because an appeal isn't like a retrial of the case. It's generally about legal errors. The Crown is specifically restricted to questions of law. So at the Court of Appeal, in any event, so they have a more narrow route, and the Crown can appeal, but they tend, I think, just for practical reasons, tend to be more selective in what they appeal. I mean, obviously, appellants, if they think that they've been wronged, they often appeal even where the odds of success on appeal might be a bit long. The Crown generally, is more concerned about the broader development of the law when they decide to launch an appeal, but they certainly have the right to do that.
I see.
So on that point, I just want to touch upon a couple of things that we just talked about.
Yep.
One of them that you just mentioned is if the defense lawyer made a mistake. So that I take it is the ineffective assistance of counsel.
For sure.
Can you tell us on what grounds you can bring such an application and what the threshold really is?
Yeah, well, it's a very high onus. It's the first thing a lot of clients want to argue.
Tell me about it.
Understandably,
My lawyer is shit.
Everyone plays Monday night quarterback after a trial, and the lawyers can do everything right. But if the client gets convicted, they often feel the lawyers let them down, right? So I mean, we hear this complaint from a lot of clients, but it's a very onerous test, and rarely does the Court of Appeal allow an appeal on that. So basically, it's a two-part test. So the first thing you have to prove as the appellant, and the burdens are, like as with all appeals, are on the person appealing, is to show that, number one, the lawyer's competency fell below a very minimal standard of competency. We don't set the bar, you don't have to have, Alan Gold or Frank Addario standard as your lawyer. There's just a basic level of competency.
Like a pulse?
What's that?
Like a pulse?
Yeah, like a pulse.
As long as you're a warm body.
Basic legal competency. So you'd have to show that it fell so far below that the lawyer's competence fundamentally made the trial unfair.
Right. And
And then you also have to show, and then even if you establish that, you have to also establish that it created what's called a miscarriage of justice.
Right.
So not only did the lawyer's conduct fall so below the standard that they're going to intervene, but the effect of that failure in conduct actually impacted the verdict or made the trial unfair.
Right. In other words, it would have been likely a different outcome had the lawyer not been incompetent.
Correct.
Yeah, so if it's an overwhelming case where the guy was screwed to begin with, then it doesn't really matter how competent the lawyer was. Is that basically what it is? If it's an overwhelming case?
Well, I mean, sometimes you can still sometimes convince the court for procedural reasons. It's not all about the outcome of the verdict. Sometimes lawyers' advice will be so incompetent that, and again, few and far between cases, but so incompetent that they just did not get a fair trial, regardless of how strong the evidence is. So it's not directly tied to the strength of the Crown's case, but certainly from a practical point of view, that's going to be looming large at your appeal hearing. If the court thinks that the client is overwhelmingly guilty and they're kind of saying, well, he could have had the best lawyer in the world, it wouldn't have changed the outcome of this case. That's certainly going to be a practical consideration. But for instance, if the lawyer, I'm trying to think of an example where perhaps
didn't review some very important disclosure.
Yeah, or didn't even explain the law on self-defense, and the lawyer, the client decided based on getting terrible, incompetent advice on that not to testify or something. It still may look like a very strong case in what was called at the trial, but because of that incompetency issue, a fundamental decision was made that would have shifted the outcome of the trial. So in some circumstances, that could still result in a miscarriage of justice, even in a case that looks objectively strong on the record. Right?
I see.
And I think some of the examples that you gave, and it makes sense. So for example, let's say a lawyer doesn't explain to the client that they have a right to silence and they don't have to testify, something like that. Those are matters that kind of happen behind closed doors with respect to instructions. Otherwise, even if there is, let's say, an incompetent counsel, the judge's role and function is a gatekeeper, right?
Yeah.
Like the judge is also supposed to
Mm-hmm.
kind of make sure that things are procedurally happening in a fair way. Is that right?
Yeah. Yeah. But I mean, 100% that's accurate. But the problem, I guess, is, and this is the reason why these appeals become somewhat complicated, is you're often dealing with things that may be happening, like you said, behind closed doors or right under the judge's nose, but because of privilege and things that are not said on the record in court, the trial judge may have no idea that this is causing like a miscarriage of justice because of the representation. Like sometimes competence may fall to the level where even the judge feels something is not right here, but a lot of times it's happening behind closed doors. And for most appeals, the issues you're raising are based on what happened at trial. Like what was the witness's evidence? What were the legal arguments made? What's on the transcript of the trial that the court can review? With a lot of these miscarriage of justice appeals and ineffective assistance being one that we see brought to attention a lot from clients. They're what are called fresh evidence appeals. So like the court of appeal is hearing, they say fresh evidence, basically new evidence is a better way to say it. Like they're hearing new evidence that is generated for the first time as part of the appeal process. And the court of appeal sometimes finds themselves in the role of having to assess credibility, review cross-examinations of the client or the lawyer, which can happen as part of that process. And they become like a quasi-fact-finding court, which is not typically the role of the appeal court, right?
Yeah.
So those, I would say, they're a little bit off the beaten track of what would be a standard appeal, but those issues do crop up from time to time.
So if I could, since we're on this topic already,
Yeah.
if I could ask you, what are 3 things, this is for lawyers listening, what are 3 things that lawyers can do to ensure that they're not the subject of an ineffective assistance counsel appeal? The 3 best things that they can do.
Aside from signed instructions.
Yeah,
You know?
but signed instructions is a critical one. Keeping good notes. I mean, clients and the lawyers often have very good relations while the trial is going on and you haven't hit the end of the road.
Right.
When someone gets found guilty, I'm not saying necessarily clients are always lying about this, although that can happen as well. And lawyers can lie about what they did or didn't do as well. Like it can be a credibility issue, right? But if a lawyer wants to protect themselves, you know, number one, the signed instructions on the key things that are in the client's control, like the decision to testify, whether to elect judge or jury, those kind of decisions, and whether to plead guilty or not. Like certainly on a guilty plea, if you're not getting signed instructions, you're really sticking your neck out there as a trial lawyer, right? Because a client can always come by after they realize, now I've pled guilty and I'm being sentenced to jail. This doesn't look so nice in here. And now I want to try to strike the plea and say I didn't give proper instructions. So the signed instructions, but even beyond just signed instructions, just a really well papered file. And I know it's hard to have the model perfectly pristine file as criminal lawyers. Like we're often dealing with a number of balls in the air. Many people are working on legal aid files where they're not paid to spend an hour after court every day to like do memos to file on everything that happened. But like I find the lawyers that cause themselves the most problems in an ineffective are ones that you open up the file and there's like, you know, 2 notes scribbled on the back of a napkin when like, you know, and it's just like, there's the disclosure and basically maybe the disclosure is marked up, but there's nothing in the file. And that lawyer fictitiously, or like that fictitious lawyer could be doing everything right. But it just opens up that avenue for a client to later say, I never told them to do that. I didn't want that witness called. I didn't want that defense raised. And if you've got no communication and nothing to paper the file, then it becomes an evidentiary issue on the appeal, right? Like it becomes a question of what you can prove and what you can't prove.
It always comes back to that. It's not what you know, it's what you can prove.
Exactly.
Right?
Yeah. And clients, like, I mean, lawyers have to protect themselves. I mean, we shouldn't be in a job of like covering our ass on dealing with clients, but you know, when you get to appellate review on this type of an issue, you know, clients can also say things that may not be true or spin things in a way that makes it look problematic. And I think you expose yourself to that greater if you don't have a well-papered file, right? Or a well noted file.
And I think that's
noted for me.
and that's
Start
what
making notes.
that's what the Court of Appeal says as well, right? It's like it's not it's not the end all and be all to have instructions, but in terms of the effort that it takes to do it, and how easy it makes their decision with respect to protecting you as a lawyer, it's just like, why would you not do that?
Yeah, and it's also like being like, I always consider it a bit an envious position as an appellate counsel to investigate an ineffective. And I mean, there's also protocols and legal rules on appellate lawyers bringing ineffectives. Like, we cannot, as an appellate counsel, ethically bring a claim forward of ineffective assistance to the court without properly satisfying ourselves through our own investigation. So not just listening what the client wants to argue. We have to investigate it ourselves and feel there's at least a prima facie, like, I don't think they use that exact language, but at least there's a foundation to suggest independently of the client that something problematic occurred, and we have to consult with the lawyer. We have to like, we can't just ignore what the lawyer is telling us before we raise it. And to be honest, like, I mean, I've probably raised 5 or 6 ineffective claims in my entire career. Like, I don't.
It probably sucks to have to do that.
Well, it is, and it's like, but it's also kind of, where you have a legitimate one, you also can't just kind of shy away from that just because it's ugly and it's going to be a miserable process for everyone, right?
For sure.
In fact, I would imagine that would. I don't know. Maybe I'm just, an asshole, but I would imagine that feels good because you're kind of showing a problem in the system. And now, mind you, it probably isn't such a common problem, but still, someone who has an allegation as a lawyer made against them for ineffective assistance of counsel. And you, like you said, the first step I would imagine is to just be like, can I have the person's file? Like their legal file. And you look at it and there's nothing in there. Then, I think the implication isn't just for the client who's come to you to bring that application to the Court of Appeal, but also for other clients that this individual may be servicing as well.
Look at what it does to all of us, right? What makes most lawyers do their job very diligently is nobody wants to be the subject of an ineffective
100%.
assistance of counsel appeal, right? That's the last thing that anybody wants to happen to them. So there's a trickle-down effect with everyone. So sometimes they have to happen, of course, right?
Yeah, it's a very, and I mean, I think most appellate lawyers, I only speak for myself, but I think most people doing this work who does due diligent appeal work, like, don't envy bringing these things.
Of course.
And we treat them very seriously. Like, I almost say to clients, like, look, and just like random advice or general advice is like, unless you have a smoking gun that says something really went wrong here, it's rare that the court is going to give effect to the credibility of the client over the lawyer in any event. So, I mean, I don't think people should be gun shy as trial lawyers to do what they feel is the approach to the case, because, I mean, you can just look at the numbers from the Court of Appeal. I mean, if there's maybe 1 or 2 successful ineffective, some years there's none, right? Like, I mean, it's a rare case that gets overturned on this issue. I'm not saying it never happens, but it's not a common ground of appeal. But at the same level, it's you have to bring them where the facts, where the evidence and the facts follow that route, right?
So just bringing it back to kind of the basics a little bit, one of the things that, and this was the second thing I wanted to talk about, one of the things that you mentioned was a position where the Court of Appeal becomes this quasi minister of the fact-finding mission. It's something to that effect. So as I understand it, obviously the vast majority of appeals are done with respect to legal errors.
Yes,
right?
That's correct.
And so when someone has a trial, the function of a judge would be that they make findings of fact and findings of law. And where it's before a jury, it's obviously the jury does the findings of fact and the judge does the findings of law. Are there any fact-finding kind of grounds on which you can bring an appeal? Yeah,
for sure. I mean, the actually very routine appeal grounds, like, for instance, what's called misapprehension of the evidence, material misapprehension of the evidence. So that's typically that would only be a judge error, because juries don't give reasons, obviously. They just say guilty or not guilty. So we don't know what their fact finding is ultimately because of jury secrecy rules. And in Canada, we don't just have a free-for-all where you can interview jurors and say, why did you get from A to B? Like
Yeah,
they do
like in the
some
States.
American, in
Yeah.
some American jurisdictions, which I think is a blessing of our system, not a curse. You know, like I always find it unseemly after a trial's done where jurors are speaking to the media and saying, this is what we were discussing around the deliberation table. So in Canada, all the jury deliberations are secret. So, but when it comes to a judge alone trial where a judge is deciding an accused fate, there's not only an obligation but a duty on trial judges to provide reasons. They have to provide reasons for their decision. And if a judge were to, for instance, get the evidence of a material witness wrong, like the material witness says, like, I don't know, for instance, in like a self-defense case, the judge says in the reasons he raised his hand like he was going to strike the person, or, you know, and that's just not the evidence. Like the witness never said that. Like you can look at what the witness testified and said, maybe he said, I was thinking about raising my fist, but he never actually did that. Because again, like judges often don't have transcripts when they're writing their decisions. They're taking notes in real time in court. Sometimes they have transcripts, but more often than not, particularly in busy provincial courts, they're just hearing the evidence in real time, processing the evidence and writing decisions, right? So it's a very difficult job for trial judges as well. Absolutely, and sometimes evidence just what goes in doesn't come out in the judgment. And if it's material to the verdict, to the point where again it would have could have led to a different result, and and a judge gets the evidence wrong, that can lead to appellate reversal. But it's a very high onus. It has to be like essential to the judgment reasoning process. So if a judge says, the witness said the car was blue and it's brown, but who cares about the car? This is an assault case or something, then you're not going to get anywhere at the Court of Appeal with that type of an argument. But if it's something that is really necessary to the underpinning of the result, and the judge gets the evidence wrong, that can lead to a factual error, which is a material misapprehension of the evidence.
And further to that, just by way of example, are there any circumstances under which a judge could make a credibility finding with respect to a witness that you can later appeal?
Yeah, there are things where that can happen. The credibility is generally specifically in the purview or in the decision making of the trial judge, and there's a good reason
they're there,
for that.
Right?
They're there, and the Court of Appeal is reading a kind of lifeless transcript. And like what, my favorite is when you're seeing an oral hearing and when a line of cross-examination just takes the air out of the room, or it's really damaged the witness's credibility. But then you get that transcript, you get the transcript of that, and you're kind of like,
falls flat.
It was just a question and an answer. It doesn't have the same effect often when you just read it on paper. So the court, because of that, the appellate courts generally will defer to a trial judge's. There's a strong level of deference. They won't interfere. So it would have to be something that generally is coupled with another type of legal error. For instance, an example would be we have case law saying you can't over-rely on demeanor in the face of numerous inconsistencies.
Exactly.
If there's numerous inconsistencies, you can't just say, I'm believing the witness because they look like they were telling the truth on the witness stand.
The witnesses perjured themselves, for example, and the judge says, oh, they're super credible.
But they look credible, or they're confident in the way they're giving their evidence. So demeanor is always a factor that a judge can consider. But if they overemphasize it, a court of appeal could interfere and say, the judge put too much emphasis on this intangible factor to the credibility, the other factors that like objectively impaired the witness's credibility, like inconsistencies between their story on the witness stand versus what they told, say, the police in a police statement. So there might be situations where credibility does get you a ground of appeal, but those are like the most difficult type of appeals.
So can I ask you something? I've had situations before that, in my mind, seemed reasonable and believable, things that my clients said, but the judge found that they weren't for their own reasons. Like, for example, I had a case where there was somebody that said, I use all of the money that I get from social services and I use it at the casino to go gamble. Yeah. Right? And he was being honest. The Crown was trying to cross-examine him on he was lying. There's no way he had enough money to do all these kind of things. And he was just saying he spent all his money at the casino as some kind of an excuse for spending it, right? And the judge found that it's unreasonable for a person, or it's unbelievable for a person to have spent all this money at the casino. People don't do that.
Mhm.
But people do that.
Yeah, exactly.
Right? So in
It's-
terms of like a credibility issue, is that something that, like, you know, I maybe I'm wrong here, but it's always been something that's confused me.
Yeah, well,
Right.
this is an interesting issue because there's a very fine line between what is one person's common sense and what's speculation or like improper inference drawing, right?
Yeah.
And I think what one person's common sense to one judge may not be another judge's common sense. So sometimes the courts struggle with the idea, is that just like, it is an error for appellate purposes to engage in speculation or conjecture.
Yeah.
You know, like you can't just come up with reasons that are not connected to the evidence to basically torpedo or reject a witness's evidence. And sometimes this comes up in the, you know, sexual assault cases for like stereotypical or myth type reasoning,
Yeah,
right?
yeah.
And that happens both for the defense side and the crown side, depending on
Right.
what the issue is. So, I mean, there is an avenue in there, but it's a fine line. Like, you would have to argue that's such an unreasonable finding that it defies common sense, and it falls into this area of like drawing a speculative
I see.
conclusion that was material to the verdict. And in some cases, if you can convince the court that that's an unreasonable finding, that might get you into a ground of appeal, right? But again, credibility are the harder issues,
Yeah,
right? It's
okay.
much easier. Like a typical appeal, trying to think of you know, like a case I won last year on a homicide where the judge just refused to leave a positive defense of what's called provocation. So a partial defense of where, you know, a witness attacked this client's wife, and he said, I got involved in the altercation with the witness because I was coming to my wife's aid, and maybe I used too much force that it wasn't self-defense, but I was provoked because of an insult to my wife to engage in this, and the person ended up getting stabbed and dying, right?
Yeah.
And in that case, the defense wanted this partial defense of provocation left to the jury, and the
Right.
judge said, I don't feel there's enough evidentiary foundation. So the judge, acting in their law gatekeeping, their decider of law role, said, I'm not leaving that with the jury. And then the Court of Appeal just decided they were wrong about that. Like, this should have been left with the jury. Like, that would be a classic kind of legal error that would result in a new appeal, because it said, look, this defense should have been before the jury.
Right.
The judge should have left it. He did not leave it,
Yeah.
or she did not leave it, and therefore you get a retrial because, you know, it wasn't properly done at the first instance.
Not to
Interesting.
mention the changed instruction on provocation as
Yeah.
well. It's the
Tricky.
threshold. It's tricky.
Yeah.
Yeah, anytime there's changes in the law, it becomes really tricky because, you know, obviously everyone's operating under the old law when the trial takes place. And sometimes changes in the law will act to the accused's benefit. Sometimes they won't, right?
Right.
But like, it's hard to fault a trial judge for, you know, applying the law as it was then when some new case comes out after the fact. But it still could be wrong, right?
Right.
So it still might result in appellate reversal. But in many cases, this is not the fault of the trial judge because he or she just thought that's what the law was, but the law has now changed by
Right.
the
Yeah.
time by the time the court gets up on appeal, right?
So again, bringing it back to the basics, Mark, can you just quickly tell us who can bring an appeal?
So an accused person can bring an appeal.
Mhm.
The Crown can bring an appeal.
Okay.
In some very limited circumstances, third parties can bring an appeal.
Okay.
And that happens more in some civil context than in criminal. But for instance, you know, the classic case was a case where a woman was testifying who was Muslim and was asked to remove her niqab,
Right.
you know, to testify
Yeah.
so that the parties could determine her demeanor.
Right.
That evidentiary ruling about that, where the judge said you have to remove the niqab to testify, ultimately got all the way up to the Supreme Court.
Right.
But it wasn't driven by the Crown or the defense. It was driven by the witness saying, like, I'm refusing to remove
Right,
I
my
see.
niqab and my headscarf or headdress, which would give more demeanor. But at the same time, you know, so some third party appeals can get up there, but it's in very, very limited circumstances. It's usually brought, I would say 99% of the time, it's
Right.
brought by one of the parties to the litigation, and that's the Crown and the defense.
And we've talked at some length about appealing what we're going to call a conviction.
Yeah.
Right. Can you also appeal a sentence?
Yes.
And can you only appeal a sentence?
Yeah, you can, although sentence appeals because of a number of changes in the law recently are a lot harder now, I think, than even when I started practicing. But you can appeal a sentence as a defendant if the sentence is what they call demonstrably unfit. So it's so excessive that even if there's no error on the part of the judge, like in applying the law, the number is just so high that the court feels it's disproportionate to what other offenders have received for that type of crime. So that's an independent basis to appeal. And you can also appeal a sentence where the judge made a mistake in applying the sentencing principles if you can show that mistake had a material impact on the number or on or whatever sentence was imposed. Because it's not just, the number of years in jail. It could be things like applying a probation order, that's like supervision by a probation officer after sentence, or, giving a jail sentence versus a house arrest sentence, what we call a conditional sentence order. You could appeal the nature of the sentence as well in some circumstances.
And I take it that's in part also because of the sentiment of the judge being in the best position to impose the sentence, when the Supreme Court of Canada says again and again that sentencing is a very individualized process and that deference has to be paid, and that sentencing judges ought to be given leeway to, sentence the particular offender in that community with that victim. So it's not an exact science, so to speak.
Yeah, and I mean, I think that's the bottom line on that's what makes sentence appeals just as a nature, like that appeal, the nature of that appeal is so difficult. Because if you look at the sentencing principles that we expect trial judges to apply to a set of facts, they're actually completely at odds with each other in many cases. In a serious crime, they're supposed to consider things like deterrence and denunciation within the same hand, rehabilitation and reparations. And, so like, how does a sentencing judge has to like engage all of these principles in every sentencing? And many times they work at cross purposes and they're very antagonistic. So I think the reason why, even more so in recent years at our Supreme Court, they've given higher and higher leeway to deference to the trial judges. Like they've given guidance to the appeal courts to say, apply a greater level of deference to sentences when you're reviewing them on appeal, is because there's a recognition that this is a very hard individualized job that judges have to do. I mean, many judges feel this is the hardest part of their job, right? Is imposing what is the right sentence, because no one sentence really fits, right? Exactly. Some judges may be more lenient. Some judges may feel they should be a bit harsher. Some judges don't, there's things that come out in the trial that reflect poorly on the accused. There's some things that come out on the trial that reflect positively, not about the offense, but just about their background or their upbringing, or, race affecting sentence is a kind of common hot button thing going on right now about how do we factor that into sentencing. Like if you're a racialized individual and you had, you got into a certain lifestyle that may cause a, in a particular economic situation or social situation that has led to perhaps explaining in part maybe why you've gotten involved in a certain aspect of criminality. How does that get factored in? And certainly different judges are going to look at that differently, right? Like it's just, they're bringing their own experience to a problem, right?
In other words, to a very large degree, I think it's the part of the criminal justice system that involves the most human element.
Yeah. Human element, discretion, judgment, however you can call it what you want, right? But I think discretion, judgment, the human aspect, 100%. That's kind of where you have to look at the person and say, okay, this is what they did now. What's that worth? In terms of, months or years of their freedom being taken away, right? It's tough.
Now, absent, obviously, ineffective assistance of counsel, should an accused person use their trial lawyer for appeal?
I would say as a general rule, no. And maybe that's self-interested on my part, but it's not self-interested in reality, because one of the benefits of using the non-trial lawyer, I'd say there's two main benefits. Number one is you get a fresh perspective on the case, right? Yeah. And sometimes what the trial lawyer sees as the appropriate approach to the case or the important evidence, when you look at all of everything as it came out the other end, there may be things that, problems with the case that they didn't attuned to that an appellate lawyer may want to argue were mistakes either made by the judge or in the evidence, etc. So, and I think that fresh set of eyes is super important. But the other thing as well is that if you do your own appeals and you appear before the appeal court on questions of legal tactics, not necessarily law,
Right.
but say, for instance, why didn't you object when the judge
Yes.
said this? That's a classic one, right?
Yeah.
Like the lack of objection. Lack of objection is never fatal to a ground of appeal. It hurts the ground of appeal because
Right, yeah.
obviously the court considers on appeal that the lawyers are the best positioned to know what evidence and what legal principles are really important. But if you do your own appeals, you could find yourself in the hot seat in the Court of Appeal saying what was going on in your mind when you didn't raise this objection, right? If it's me, if I know what was going on, I can't mislead the court. So I'll have to be forthright if I get asked a question like that. But many times as an appellate lawyer not doing the trial, you're just like, well, I don't know why the lawyer did this, but that's not the right approach to the law.
Yeah.
The judge, the buck stops at the trial judge and he should have got the law right, right? So I think clients could put themselves potentially in a disadvantage by having their trial lawyer, but I don't think it's a binary rule because there's some things like, I'm trying to think of some appeals, like say for instance, an appeal that deals with charter issues, say, or like your rights to your breach to counsel, which is just a pure legal question.
Yes.
Maybe the trial lawyer is not in any better or worse position than having an appeal lawyer, and the trial lawyer knows the record better than any appeal lawyer. Like I can read the case and get up to speed on the case, but I didn't live the case like a trial lawyer did, right?
Yeah.
And I didn't deal with the ins and outs in court. I wasn't taking the temperature of the room. At some levels, we try to learn as much as we can about the case from talking to the trial lawyer, from talking to the client, but you're still a third party coming in after the fact trying to reconstruct what occurred.
Right.
And I just don't think you have the same perspective as the parties that were there arguing. And I think you need to recognize that as an appeal lawyer, that you often are somewhat aloof. And, just the way you see it as a Monday night quarterback is not exactly the same as it may have played out at trial, right?
Because I see that with myself. Sometimes even defense lawyers are guilty of getting tunnel vision, right?
Yeah.
They think that they have an argument, they think it's the right argument. They develop their entire case, all their questions are on this one argument. And you convince yourself and your articling student and your partner and whoever else who's around you that this is the right thing to do, right?
Your mom.
Yeah, your mom, your dad, your uncle, whoever it may be, right?
Yeah.
And it may not necessarily be the right case because like you said, you've been so focused on perhaps this one issue because you can't argue every issue at a trial, obviously, right? You have to pick the ones that are good and the ones that are going to stick and the ones that are going to come across the best, right?
Yeah.
And
in the right case, hopefully the appeal arguments follow the trial arguments. I mean, that's if I pick up a file and the lawyer says to me, I objected to these 3 things, the judge didn't give the right legal instructions, and I can just go do the research and prove the lawyer was right, those are the appeals that have the best chance of success.
Yeah.
Because you're not trying as an appellate lawyer to kind of like sidewind some issue that wasn't, not that sometimes there are issues that the lawyer doesn't raise, like you said, or they get tunnel vision or they see it one way and there's other things going on. But in a perfect world, the appeals that have the best chance of success is where both sides, the appeal and the trial counsel, are not working at odds with each other.
Yes, of course.
Right? That like, this is the problem, and then it plays out in the trial. And often those are the ones that we call, like if it's about the state of the law, what we call kind of jurisprudential appeals. Like they're not just correcting an error. Like there might necessarily be some uncertainty in the law. And that is another function the appeal courts serve, is they're the final arbiter, at least the Court of Appeal or the Supreme Court, in resolving things that are just muddy in the state of the law, right? And those are less common than kind of what we would call error correcting appeals, or just ones that, something went wrong, the judge got the evidence wrong, it wasn't fair, do it again, right? Like sometimes you're dealing with like the interpretation of a statute that has never been interpreted before. Like for instance, the recently in the sexual assault context, all these record disclosure regimes went up to the Supreme Court. And this was a whole piece of legislation brought in by the Liberal government that trial courts, different judges were struggling how to deal with this in the trial in real time because they don't know what exactly the intention of Parliament was or how the nuts and bolts of this should play out. And it went all the way to the Supreme Court, and the Supreme Court had to say, this is what you're doing. Like, this is the correct approach, right? So
this is the correct approach you should use.
maybe not everyone would agree on that. The correct approach, but
this is what you have to do.
The Supreme Court has said that's the correct approach, so they give clarity to that.
Stay tuned for part 2 of Criminal Appeals with Mark Halfyard.